Mr Tidwell, earlier today I think you indicated you might be able to give us details of any of the agencies within answerable to the Attorney-General who might use external consultants.
I may
have misinterpreted you, sorry, when we were discussing...
No. So I should say there is a core work policy
yes.
of the government which is very focused on paring back of...
I'm pleased somebody's aware of that policy.
Right.
Yes.
And I am being diligent, as I should be within the department. I do not have, it's very rare, that I would have line of sight or oversight of the consultancy arrangements in any other agency within the broader grouping.
Right, okay, thank you. On notice, are you able, without, I don't want to put you to an extraordinary amount of work, on notice are you able to provide us with which agencies are using external consultants?
I believe I could, yes.
I would appreciate that if you could. Thank you very much. Dr Cockayne, if I could come to you. You'd be aware that following the inquest into the death of Jerwin Royupa and questions in the House, at his invitation I wrote to the Treasurer in relation to providing adequate funding for the anti-slavery hotline. Have you had discussions with the Treasurer about this funding?
Thank you, Mrs Cutter. I am aware because you kindly copied me on your correspondence, and I have taken that opportunity to make representations to the Treasurer. Some of those will be subject to the relevant budget considerations. However, I can share with you my estimate to answer directly the question that you've put as to the cost to run the hotline 24/7 in a trauma-informed way. This is an estimate based on precedents from analogous DCJ hotlines. That estimate is that it would cost at least $8,890,712 over 3 years.
That's a very precise estimate.
It's an estimate nonetheless.
Yes.
For example, we were not able in appropriate time to factor in overtime considerations. But as I said, it's based on, it's only my modelling, it's not the government's modelling, I should be very clear.
So that's a 3-year figure, three-year
It's a
estimate?
3-year figure.
And does that also include advertising appropriately the existence of the hotline?
It would, yes.
Right, okay. Thank you very much. And have you had any discussions with the Attorney-General about adequate funding for the anti-slavery hotline?
I'll take that on notice.
Okay, thank you. And have you had any meetings or have you been asked to provide any advice to the Attorney-General or his staff or departmental staff about measures which we are able to take to protect overseas women from becoming breeding slaves for New South Wales families?
Can you just restate the beginning of the question, please?
Sorry, have you been asked to provide any advice or have you had any meetings with either the Attorney-General, any of his staff or any departmental staff about what measures we are able to take to protect overseas women from becoming breeding slaves for New South Wales families?
Again, I'll take that on notice, please.
Great, thank you very much. You've previously shared with us information, for example, about a clinic in Greece where 97 women were found to have been trafficked into surrogacy slavery, a clinic used by New South Wales families. Have you any reason to believe that the position of women in certain overseas surrogacy clinics, if we can call them that, has changed, or is surrogacy slavery, as far as you're aware, overseas, a problem which persists?
I have no particular reason to believe the situation has changed in any particular direction.
Right, thank you. So it's an ongoing issue with which we should still be concerned, would be your view?
All the information I have, Mrs Carter, is that vulnerable women and vulnerable families that are drawn into poorly regulated commercial surrogacy arrangements may end up in exploitation. And I emphasise the poorly regulated. There's what I would say, Mrs. Carter, just following also on from the line of questioning this morning, is that the Australian Law Reform Commission has recently published a very useful discussion paper on surrogacy law in Australia, and I think that was in November 2025, if I'm not mistaken, and certainly that paper deserves careful consideration.
Okay. Thank you very much. My colleague mentioned it earlier, your letter of the 9th of March to Commissioner Barrett of the Australian Federal Police in relation to suspected exit trafficking in relation to the Iranian women's football team. Can you outline what your concerns were, and if you're able to update us on what happened as a result of the complaint that you made to the Federal Police?
Yes, certainly. So I'm sure, like many in the committee and many Australians more broadly, I've been very distressed by the reporting around the Iranian women's football team, known as the Lionesses, and the indications that there may be coercion or threat involved in securing their exit from Australia and return to Iran. Under Commonwealth criminal law, if made out on the facts, that could potentially constitute exit trafficking under section 271.2 of the Commonwealth Criminal Code. I have a function and a responsibility under the Modern Slavery Act here in New South Wales to report cases of suspected modern slavery offences to suitable enforcement bodies, and the Australian Federal Police has the lead in investigating modern slavery offences. So on Monday night I wrote to Commissioner Barrett referring to her for urgent investigation the suspected modern slavery offence of exit trafficking in relation to the members of the Iranian women's football team and support staff. I've been very heartened since Monday night to see the developments that have led to the offering of asylum for reportedly 7, although it appears that in the last few hours one of those who had accepted may now have changed their opinion. I particularly welcome the efforts by the Albanese government to focus on the dignity and safety of the people involved here. The whole question here is how to create an opportunity of felt safety so that someone who may be a victim of human trafficking is able to freely express themselves and reclaim agency in their own lives over the extraordinarily difficult decision whether to return home to a war-torn country with a highly repressive regime or stay with a very uncertain future far away from family and all that represents. So I've been really heartened by that. However, I still do have questions, Mrs. Carter, about the role of the AFP in this affair. I have not received a substantive response yet, probably understandably, from the Commissioner. She's had a very busy few days, no doubt. But the questions that I and suspect others might have would include these. Did those women or the support staff ever receive independent legal advice? We know from a statement from Minister Burke this morning that an opportunity was afforded to them to meet privately with a member of the department, a representative of the Department of Home Affairs with an interpreter. Did they ever have the opportunity to get independent legal advice? Did the AFP ever interview either them or the 5 women who'd already accepted asylum as of Tuesday morning to investigate whether there was in fact coercion occurring and whether there was a modern slavery trafficking offence afoot? If not, why didn't the AFP investigate exit trafficking after I referred the matter to Commissioner Barrett on Monday night? We know that the AFP was involved in facilitating the departure, the exit of the team from Australia through New South Wales, through Sydney Airport. No doubt there were public safety reasons to be factored in there. But given that I had referred the matter to the Commissioner of the AFP, a view may have needed to be formed as to whether there was coercion on foot and whether that facilitation may then unintentionally have been contributing to an ongoing trafficking offence occurring in New South Wales at the time. I'd also be curious as to whether the conversations were limited to an offer of asylum, or whether the women were also informed that they may be eligible for a human trafficking visa and all that that entails. Were they, for example, ever given the number 1-800-FREEDOM, the support hotline that we run, that you referred to earlier, that I'm mandated to run here in New South Wales? So those are certainly my questions of the AFP. There may also be questions, frankly, for others that have responsibility to respect human rights, such as Sydney Airports and indeed Qantas.
With respect to the matters you've raised in relation to the Australian Federal Police and putting those to one side and focusing on New South Wales Police and reflecting on the recommendations of the coroner in the Raiupa inquest, do you have any role in assisting the New South Wales Police in developing training so that they can recognise slavery, they have tools to deal with potential situations of slavery, and they have networks where they can appropriately deal with anybody who is suspected of slaveholding or being in a position of slavery?
Yes, potentially, and I welcome the recommendation in that inquest that I work with the Commissioner of the New South Wales Police to try and develop such training, and indeed we have conversations ongoing. What I would say there is that we are very pleased with the engagement we've had from the New South Wales Police and more broadly from the New South Wales Government in the recent years, with a focus on developing frontline worker training. I think it was in the last estimates that I called attention to the very positive step taken by the department to institute basic training for more than 28,000 staff. We also see a positive movement by the government on related arrangements to ensure that there is frontline inspection capacity, if I can put it that way. The recent adoption of or creation of the Construction Complaints Unit within New South Wales IR, the indications from Minister Kotsis yesterday of a move towards immediate work on labour hire licensing, and in many other areas there are very positive signs. The challenge here for all of us, because this is an issue that has long had multi-party support, which I greatly welcome, the challenge here for all of us is to have a very clear program and agenda, and as you've highlighted in your questions, Mrs. Carter, to ensure that we're adequately resourcing all the agencies that are now expected to do this work, whether it's the police or New South Wales Industrial Relations, Safe Work, airport, transport workers and so on. So there is a big set of work ahead of us.
With respect to resourcing, can I perhaps ask you some questions about resourcing in terms of healthcare? Are you familiar with any of the evidence given at the hearings of the Modern Slavery Committee in Coffs Harbour in December last year?
Yes, certainly the public evidence, yes.
Yes, and you'd be aware of the evidence given by volunteers from the Lily Rose Pregnancy Support Service in Coffs Harbour, which apparently sadly is no more because of lack of donations. And they outlined the difficulties faced by pregnant migrant workers who, with no access to Medicare, are often unable to obtain antenatal care. Is this an issue that you are able to address?
Yes, hopefully my machine here cooperates. We've certainly seen, Mrs. Carter, recurring issues raised by temporary migrant workers who are struggling to access antenatal services throughout rural and regional New South Wales in particular, for several reasons. First of all, simply the lack of available safe and suitable services that particularly impacts those at the margins of society. Secondly, though, the limited access that many of these people have to Medicare and appropriate private health insurance. So take, for example, the Pacific Australia Labour Mobility Scheme. Those workers are not covered by Medicare. Their employers are required to work with them, the workers, to ensure there is appropriate health insurance in place.
In your experience, does that always happen?
In general, it does,
Okay,
but one of the
encouraging.
challenges in relation to antenatal care is that there's only partial or no coverage of antenatal care under the two policies that are made available.
Well, is that something that needs to change? Because clearly there's a significant number of women needing antenatal care and needing delivery care.
Yes, certainly I would agree that's the case. We have a number of important recent research reports beyond the evidence that you pointed to that make this clear. And a recent report, Improving PALM, the Pacific Australia Labour Mobility Scheme from the Scanlon Foundation Research Institute, for example, quotes a local doctor stating, "It's harrowing to realise how vulnerable so many people are. Women who are pregnant are presenting very late in pregnancy with syphilis that has not been treated. They have very little access to reproductive health care and are presenting so late that they have pelvic abscesses and sepsis and need 2 weeks in ICU." Now, if we think through the consequences, 2 weeks in ICU, who's going to pay for that? Ultimately, the people of New South Wales are bearing those costs, and in many cases, out-of-pocket costs may be also borne
Not to
by
mention the
members
cost
of
to
the
the woman
community.
of suffering pelvic abscesses.
Yes. And there are several other reports that, if I might take it on notice, I could provide the committee.
Thank you, that'd be
the
helpful.
references to.
I mean, Dr. Little testified that, quote, "Hospital billing staff have approached women during the induction of labour to require payment." Everybody understands that we have to pay for healthcare, but if these workers are coming at our request on the visa terms that we set out, what are we doing to ensure that they have adequate access to basic medical care, which for women I suggest would include antenatal and maternity care?
So let me come, if I may, Mrs. Carter, back to the terms of the private health insurance policies that are in place for people while they are on this scheme, for example.
Yes.
According to our information, one of those from NIB partially covers pregnancy and birth-related services.
When's the last time someone was partially pregnant?
It partially covers.
No, but the point I'm making is
Yes.
that's not very useful. Yes. Yeah.
Secondly, the Medibank product has a 12-month wait for pregnancy and birth cover and doesn't cover hospital treatment for the investigation and treatment of a miscarriage or for termination of pregnancy. Now, that's all while you're under the scheme. If you disengage from the scheme, that's when you're in real trouble, because when you've disengaged from the scheme, or even under some of the contracts, when you become pregnant, that's a basis for the termination of your contract, disengagement from the scheme. So now you're a vulnerable worker in rural or regional New South Wales with expectations from your family and community at home that sent you here to earn money. You're pregnant, you've lost your work, you may have lost your entitlement to visa status. It's a very, very dangerous situation, and the reports we receive through the 1800 Freedom Hotline make clear there are women across rural and regional New South Wales getting pregnant, having kids in our hospital system who are not appropriately covered by healthcare because we haven't designed the system in a way that takes the reality of life into account.
And there was also evidence given in that inquiry about women who are free birthing, which is not recommended for the health of either the child or the woman, but they have no other choice. So, look, we welcome any information you can provide us, because I think this is an issue that will be ongoing. Ms Dowling, if I can turn to you, just some follow-up questions. You indicated that part of the work that you were doing with the external media advisor was, I think you put it, to build media capability. I'm just wondering, in what way has the work of the ODP changed that that media capability needed to be built?
It's not the work of the ODPP that has changed, it's the media landscape that has changed. And the qualifications and experience of the people within the ODPP who are tasked with responding to media inquiries.
And sorry, in what ways and over what time frame has the media landscape changed?
It's changed over the last 5 years at least.
In what way?
The volume of media inquiries has changed.
Yes.
The tone of them has changed.
Tone in what way?
Oh, the tone has, well, yeah, I mean, look, it's no secret, Mrs. Carter, that there was a very sustained campaign in the national media. Would you like me to finish the question?
Yes, I would.
Great. That there was a lengthy campaign questioning the prosecution of sexual offences by my office, and as you know, that resulted in a very meticulous and extensive review by my office, and of course that included a review of the conviction rates and a review of all the current matters that were in the office in 2023 that revealed that there was no basis to that. So that's an example of a change, a shift in the media landscape.
So could we summarise by saying more scrutiny of your office?
No, I don't.
So how
I wouldn't
would
agree
you, how
with
would you
that.
characterise
Well,
it if it's not scrutiny?
I have just characterised that as that was a whole body of media attention in relation to a particular issue that required a media response.
If we're not using the word scrutiny, what other word do we use for it?
Well, that's your word. It's not my
Well,
word.
that's what I'm asking. I'm inviting you to choose another word.
Well, I've given my answer.
Sorry, which word have you given? I missed that.
I'll have to refer back to the Hansard because I've just given you my answer, Ms. Higgins.
All right, thank you. You indicated that you had junior media staff and they needed training. Why did you employ junior media staff?
At that time, we went from having a media officer who had a higher level of experience. She was working part-time and then she later stepped back from the role. And then the person that came in to the role didn't have that journalistic background, didn't have the same type of background.
I think that's my question. Why was that person employed if the
Look, I'd
person
have
was
to-
too junior for the role as it was evolving?
You know, with the benefit of hindsight, you know, that's a question that can only be answered with the benefit of hindsight. So there was a proper and rigorous suitability assessment and recruitment process that was undertaken.
And the engagement of the external media advisor, on what date was that external media advisor first engaged?
I'll have to take that on notice. It was in
Thank you.
2024, I believe.
Yeah, and it's an ongoing engagement?
It is.
And was that a tender process or you approached a person directly?
I will have to go back and review that. It was not a tender process, is
Okay.
my understanding.
So was it, but did you reach out to Bridget Glanville or did you invite expressions of interest from a range of identified people?
As I said, it was not a tender process.
Yes.
I'll have to go back and review how that initial contact.
Sorry, it's
Came up.
2024. I'm not asking for the.
You've
the
asked me-
I'm asking you. Did you
This
pick
is-
up the phone to somebody that you had identified, or did you put out expressions of interest saying, "This is the sort of work we want done. Tell us if you're
We
interested."
did not put out an expression of interest. There was not a tender process.
Right.
I do not want to give evidence that is incomplete or inaccurate in any way. And I have informed you that I will take this question on notice and I will give
Thank
the
you.
committee considered response.
Thank you. Earlier today, in answer, I think, to Ms. Higginson's questions, you talked about what was happening in the ODPP in relation to greater awareness and education in relation to responsibilities around guarding information in relation to children in legal proceedings. And you made reference to the references in the prosecution guidelines. Have the prosecution guidelines changed since the
They have
proactive?
not, no.
So therefore, that's not a measure that's been taken in your office to address that, is it? Because the prosecution guidelines always indicated that it was inappropriate to release information in relation to children to the
Yeah,
media.
that's correct. I didn't suggest that they had been changed.
So I clearly misunderstood then.
I'm sorry about that.
And I think also in answer to questions from Ms. Higginson about the young person's experience of this incident, you indicated that your office was unaware whether that young person was even aware of the media coverage. I understand that you've been in contact with, I think, Indigenous workers in your office who had been in touch with people in the area in which the matter was decided. Have you reached out through them to establish contact to check on the welfare of that young person?
Not that I'm aware of.
Not that you're aware of.
No.
Okay, thank you.
It's a convention that when a person is involved in litigation and has the services of a legal practitioner, it is a convention that it would be inappropriate to reach out to that person directly without going through their legal advisor.
Did you consider going through their legal advisor to check on the welfare of that young person?
My understanding of the evidence of the legal advisor is that he is not aware whether the young person knows and has been unable to get instructions.
Thank you very much. Putting aside matters currently before the inquiry into identity protections for children, did your external media advisor suggest providing proactively any other media stories to particular media outlets?
My initial answer to that is no, but I would need to go back and confirm that with my internal records or our internal records.
On notice, are you able to provide us with all the written advice that you've received from the external media advisor?
Subject to issues of legal privilege.
Sorry, what legal privilege subsists in relation to media advice?
It depends. It depends if the advice is relating to privileged material, then that advice may be privileged. I need to consider that.
Okay, all right, thank you. Other than the external media advisor, what other consultancy services are you using?
I'll have to take that question on notice. There are accounting firms that offer consultancy advice.
Yes.
We're currently in the process of tendering for some external education consultancies. So we try to keep it to a minimum, but obviously we do not have the requisite expertise to do all of the things that we need to do.
And then perhaps on notice you can provide the total cost of the external media advisor services to date and any other external consultancies to date. I was encouraged by an answer to a question from Ms Higginson earlier in relation to the openness of your office to engage with stakeholders, and I note your reference to the inquiry into the sexual assault cases, and you would know that there were persons who were deeply affected by a decision, especially a decision less than 2 months away from a trial, to proceed to trial. Have you been able to reach out and proactively meet with those persons and address any issues of distress that they may be feeling?
I'm not entirely sure which matter you are referring to, Ms. Carter.
You indicated that you welcome talking to stakeholders and anybody who's affected. Are you not aware of any women who have been disturbed by the decision not to proceed with their matter close to trial?
There are complainants who are distressed at decisions to not proceed with matters, and they are consulted and they are spoken to by the prosecution team usually, and on occasion by myself.
If there are particular issues that they may have, so for example, if a woman suffered significant physical injuries as part of a severe assault during a sexual assault, and because of the focus on preparation for trial, which did not proceed, missed the cut-off to apply for support through victim services so that there could be funding to repair some of the physical injuries, what sort of practical supports are available for women in those circumstances?
That's not an answer that I'm able to respond to. Perhaps that is a question more appropriately directed to my colleagues from DCJ.
Mr Tidball or Ms Campbell or Mr McKnight, any insights into that issue?
I'd need a little more detail before commenting
so
on it.
A woman
but
has
perhaps-
suffered significant physical injuries as part of a sexual assault. She needs expensive medical treatment to repair those physical injuries. She was under the impression that the matter was going to a criminal trial and then potentially would have been able to bring a civil matter if she needed to, using the verdict in that criminal trial. She missed the cut-off for victim services because she's so focused on the preparation for the trial that she missed the 2-year time to apply. She now finds she has extensive medical costs relating to a severe assault and apparently no avenue to seek any support. I'm just wondering what the options are for those women.
There's no requirement under the victims scheme to prosecute a matter.
No, but the
or
requirement is to apply within 2 years. And if your focus has been on preparation for trial...
So there would have been no barrier to her applying for
I suggest, Mr
economic
McKnight, the
costs.
barrier was the recovery process from a severe sexual assault when you're focusing on preparation for trial. That was the barrier. And the 2 years elapses.
Mrs. Carter,
Yes.
I hear the gravity of the matter,
Yes.
and rightly am not without sensitivity or compassion.
Yes.
When I hear what you describe, I don't know what is possible. I'm certainly happy outside of the hearing to engage
Thank you.
in relation to this matter.
Thank you. Thank you. I appreciate that. Ms Dowling, the most recent New South Wales employee survey indicates that 2/3 of your staff feel mentally exhausted by their work most days and feel burnt out by their work. And this sadly has gone backwards from the last survey. What work are you or your office engaged in to address these issues?
Thank you, Mrs. Carter. I would like to preface this by saying that across the board, our People Matter survey results have improved
Great.
distinctly
That's
over the
excellent.
last 3 years, and I just wish to thank the incredible work done by the executive within my organisation to achieve those improvements, and I very much look forward to continuing that upward trajectory.
Mm-hmm.
In terms of the well-being of our staff, we have and I use these words with consciousness of their significance, world-leading practice across prosecution agencies in terms of supporting prosecution lawyers to perform their arduous tasks. So we have, of course, our employee assistance programs, we have vicarious trauma training, we have a very, very well-developed formal mentoring program, we have a workload weighting tool, we have a psychosocial risk register. We are shortly engaging in some before operational stress programs that we're going to roll out. We have mental health first aid training for all managers and for anybody else who wants to do it within the organisation. We have a wellbeing task force that meets regularly, of which I am a member, and actually I won't stop there, we are about to trial compulsory debriefing in a range of homicide matters for the prosecution teams. We have 6 monthly well checks, which are conducted by qualified psychologists who have got specialist training in the area of prosecution practice, and they are not all of our programs. They're the ones that spring to mind and roll off my tongue.
No,
we are always looking for ways to better support our staff, and principally our understanding and our research shows that workload is a really significant factor in mitigating against and protecting against burnout. And so in the last budget, we were very, very grateful to receive a significant increase in budget that has allowed us to employ an extra 65 people. That has reduced the span of control for our managing lawyers, which has been extremely well received both by the managers and by their teams. And we are actively recruiting to make sure that we are fully staffed. As you would appreciate, recruiting and retaining experienced prosecution lawyers is not an easy thing, particularly in our regional centres. So that is an ongoing challenge for us, and we are, in fact, looking at creative ways to increase our recruitment and retention in the regions.
Mm-hmm.
We are actively engaging with high schools and universities, particularly in the regions, to see if we can identify young lawyers who live in the bush and want to stay in the bush. And all that goes into better supporting all of our staff to do their difficult jobs.
I'm curious, Ms. Hitter, because legal aid must have a lot of these same workplace issues that ODPP has.
Yep.
I mean, do the organisations talk to you, share programs that work, that support staff?
Absolutely.
We have a very high level of connection, particularly between our HR and wellbeing teams. And Ms. Hitter and I regularly discuss these types of programs. We share resources and we share ideas.
Excellent. Oh, thank you. Just one last question from me, if I may, Chair. I'm just wondering, Ms. Dowling, if you want to review your evidence. I don't have the transcript in front of me, but I understand from somebody who does that the evidence given by the young person's solicitor, that your recollection of it differs from the evidence that he gave, that apparently, I am informed, I don't want to put it any higher than that, that the evidence that the young person's solicitor gave was not that he didn't know whether he had been affected by it, he was not in touch and not able to get instructions. So I just wondered if you wanted the opportunity to review your evidence.
Thank you, Mrs. Carter. I don't have that transcript in front of me. That is one of the difficulties with appearing in this important forum without notice of the important topics that you wish us to respond to. And I have never, ever intended to mislead this Parliament in any context. I do my best, as do all of the witnesses here, to respond to the important questions that you put to us. That was my recollection, and I apologise to this Parliament if it was incorrect. The record will of course, stand for itself. However, you know, that is one of the difficulties of being asked questions without notice about complex things that happened some time ago.
I understand. One last question, if I may. The meeting with the external media advisor, the internal media advisor, yourself and another lawyer, where matters were discussed in relation to release of information to 2GB. What was the name of the other legal advisor who was in that meeting?
As you are aware, it's Mr. Hyland's practice and mine here not to name individuals in this forum. However, I will be responding to the inquiry's correspondence shortly.
Okay, thank you very much. That's very done.
Thank you. I'll come back. Thank you.
I just have one question for you, Mr. Tipple.
Of course.
I'm really looking for advice. I have received certain information raising issues about the way in which the Law Society is fulfilling statutory functions in relation to trust accounts, also raising issues with respect to the role of the Legal Services Commissioner. Is that an appropriate matter to be raising with you or anybody in this room, or is that a matter for other people?
So the Office of the Legal Services Commissioner and the agencies of regulation do have an accountability to the attorney. As you're aware, the regulatory system is a co-regulatory system with the Bar and the Law Society, but the entry point for complaints being the OLSC. I certainly am, if I have knowledge of matters that should be raised in the first instance with the OLSC, I'm quite prepared to do that.
It might be appropriate perhaps if I write to you and
Of
share
course.
the information that I have.
Of course, yeah.
Thank you very much. Thank you.